The Vampire's Bite, a secret war on your rights. I was deep behind enemy lines in New York this past weekend when the news broke. It hit the wire like a thunderclap, a shockwave that sent tremors through the entire anti-gun establishment. The Supreme Court has just taken a massive Second Amendment case, and I'm telling you right now, I'm calling it, this is going to be a bloodbath for the gun grabbers. While the case itself, Wolford v. Lopez, originates from Hawaii, you can bet your last dollar that tyrants in California, New York, New Jersey, and Maryland are sweating bullets. Their entire house of cards is about to come crashing down. And I'm going to let you in on a dirty little secret. A backroom maneuver they pulled in New York that you need to watch for, because it's a telltale sign of their desperation. Today, we are staring down the barrel of a Supreme Court showdown that could fundamentally reset the rules of concealed carry in this nation. This isn't just another case. This is about a diabolical legal trap known as the vampire rule. It's a twisted, suffocating scheme designed to make your right to carry a ghost, a phantom, that exists on paper but vanishes in the real world. It's a strategy that flips our most basic assumptions of freedom on their head, declaring you a criminal by default. If you care about the Second Amendment, if you believe in your right to defend yourself, and if you want to understand the high-stakes chess match being played in our courts, you need to stay locked in. I'm going to walk you through the battlefield, the legal ammunition, and the soul of what's at stake. All right, let's sink our teeth into this. What exactly is this vampire rule? For those of you living in the 45 free states, you've probably never even heard the term. It's a battlefield designation we coined, and it perfectly captures the insidious nature of this legal poison. Think about the old horror movies. A vampire cannot enter in your home unless you personally invite him across the threshold. That is exactly how this law works. This rule makes it illegal by default for a law-abiding, licensed, concealed carrier to step foot onto private property that is open to the public unless the owner has explicitly posted a sign giving you permission. A concealed carrier cannot cross the threshold into a store, a restaurant, a mall, or even a private residence without being invited in with their firearm. This isn't just a restriction. It's a fundamental inversion of American liberty. It presumes you are a threat. It presumes you are a criminal. It strips you of your rights the second you leave your home. It used to be that you were free to carry anywhere, unless a private owner posted a sign telling you they didn't want your business because they hated your rights. We all knew who they were, and we took our money elsewhere. This rule flips that script. Now, you're the one who's guilty until proven innocent, and freedom requires an invitation. Bruen's echo, the legal chess match. This entire scheme, this vampire rule, is a direct and calculated assault on the very foundation of the victory we won just a few years ago. Gun rights advocates argue, and they are 100% correct, that this effectively quarantines licensed carriers from vast portions of public life. It's a backdoor ban. It completely undermines the general right to carry that the Supreme Court affirmed in the landmark case New York State Rifle and Pistol Association versus Bruen back in 2022. So the question that Wolford versus Lopez forces onto the table is brutally simple. Is this kind of suffocating prohibition constitutional, or does it spit in the face of the Second Amendment? And like I told you, I am predicting an absolute thrashing from the Supreme Court. To understand the kill shot that's coming, you have to understand the weapons in this fight. We need to recap two monumental Supreme Court precedents. First, there's Bruen. In Bruen, the court laid down a new law of the land. It held that when the government dares to restrict your right to publicly carry a firearm for self-defense, it bears the burden of proof. It must demonstrate that its restriction is consistent with this nation's historical tradition of firearm regulation. In plain English, the court said, show us an identical law from the time the Constitution was written. Is there a historical analog, a twin to the modern law you're trying to pass? If the answer is no, the law dies. Period. Point blank. It was a clean, powerful, and righteous standard. However, the court in Bruen left a crack in the door, a detail the anti-gunners immediately began to exploit. The decision acknowledged that certain sensitive places, think schools, polling places, government buildings, could justifiably be made off limits to firearms. But Justice Thomas warned the lower courts not to get creative. He explicitly said you can't just wave a magic wand and declare every public square or every city bus a sensitive place. But that's exactly what they've tried to do. Now, enter the second precedent, the more recent case of U.S. versus Rahimi from 2024. Rahimi didn't overturn Bruen, but it tweaked the focus. The court in Rahimi clarified that the historical test isn't a rigid time-traveling exercise where you need a perfect one-to-one carbon copy of an 18th century law. That said there has to be room for analogous reasoning, for applying the principles from our historical tradition to modern problems. In short, a modern gun law has to be consistent with history in a principled way, but not necessarily a mirror image of an old statute. This gave the anti-gun states a little bit of breathing room, but it was by no means a blank check. And this is the crucial weak point the enemy is trying to punch through. In the Wolford versus Lopez case, the notoriously liberal Ninth Circuit leaned with all its weight on the Rahimi decision. They used it to uphold Hawaii's vampire rule, arguing that even if you can't find a perfect historical analog for this modern opt-in scheme, you can rely on general regulatory principles from history. The question now, hurtling toward the Supreme Court, is a dangerous one. Will they accept this twisted and expansive reading of their own words? Or will they slam the door on this blatant attempt to gut the Second Amendment from the inside out? A nation divided. The circuit court war. What makes this Wolford versus Lopez case so absolutely compelling is that the lower courts are in a state of open warfare over this very issue. And that chaos is the dinner bell for the Supreme Court. The highest court in the land typically doesn't get involved unless there's a deep, irreconcilable split in the circuits below. When the Constitution starts to mean one thing in the West and something completely different in the East, the justices have to step in to restore order. That's precisely why the Supreme Court has granted a writ of certiorari for this case. They are officially taking it up. We are going to see this fight play out on the biggest stage. Let's look at the battle lines. On one side, you have the Ninth Circuit. They became the very first and so far the only federal appellate court to uphold a vampire-style law. Their ruling on Hawaii's statute was a watershed moment because it defiantly bucked the trend we were seeing in the rest of the country. They drew their line in the sand, creating a safe haven for this unconstitutional poison. On the other side, you have the forces of reason. Over in the Second Circuit, the court struck down a nearly identical default ban in New York that targeted publicly accessible private property. This was part of the disastrous Concealed Carry Improvement Act that Governor Kathy Hochul frantically shoved into law. Immediately after, the Supreme Court slapped her state down in Bruen. And here's the kicker. Even after the Supreme Court asked the Second Circuit to reconsider its decision in light of the Rahimi case, they stood their ground. They took another look and reaffirmed their original view. These laws likely violate the Second Amendment. That is a massive signal. Then the cavalry arrived. The Third Circuit also intervened, blocking New Jersey's attempt to implement its own version of a vampire rule. Their reasoning was surgical. They acknowledged that some historical regulations on carrying firearms in specific contexts might exist, but they looked at the sheer scope of the modern law, the how and the why, and concluded it was so ridiculously broad that it had no roots whatsoever in American tradition. So what you have is a true circuit split, a legal civil war playing out in real time. The Ninth Circuit has carved out a lonely, defiant path to uphold these laws, while other powerful circuits are rejecting them as the unconstitutional garbage they are. That fundamental divide is an open invitation, a demand, really, for Supreme Court intervention. And the stakes couldn't be higher. This isn't just about one statute in the middle of the Pacific Ocean. This is about how far states can go to erase your right to carry in the places you go every single day. If the Supreme Court sides with the Ninth Circuit, it will give a green light to every blue and purple state to pass their own vampire laws. And if you think they won't, you are living under a rock. But if the Supreme Court strikes it down, it will be a thunderous reaffirmation of our right to bear arms in public, putting a stake through the heart of these anti-gun schemes once and for all. Judgment Day. 4 paths to victory or defeat. So as we stand on the precipice of this decision, what are the possible outcomes? How could this Judgment Day play out? Let's war game the scenarios. First, the best case scenario. The Supreme Court strikes the vampire rule down hard. This would be a total victory, a clean kill shot to this entire un-American concept. The court could hold that making the exercise of a constitutional right illegal by default is so far outside our nation's historical tradition that it is fundamentally inconsistent with the principles of Bruen. That would be a massive, earth-shattering win for gun rights advocates and a stake driven straight through the heart of the anti-gun agenda. It would send a clear message. The right to carry is not a privilege to be begged for. It is a right to be respected. The second possibility is a dangerous middle ground. The court could uphold the law, but with severe limitations or narrow carve-outs. This is the politician's answer, and it should make every gun owner nervous. This would mean the court might allow some twisted variation of the vampire rule to survive, perhaps requiring certain categories of property to permit carry by default or limiting the rule to extremely narrow contexts. They could uphold Hawaii's law in a very confined way, but that would still leave the door open for future abuse and endless litigation. It's a compromise that satisfies no one and solves nothing. The third option is the nightmare scenario. The Supreme Court upholds the law broadly. This would be a catastrophic defeat. It would mean the court buys into the Ninth Circuit's corrupted reasoning that modern laws can diverge wildly from history as long as they're vaguely grounded in general principles. This would be a betrayal of Bruen and would effectively hand states a blank check to legislate the Second Amendment into oblivion. It would give them the green light to push ever more creative and restrictive carry regimes, hollowing out our rights from the inside until there is nothing left but a useless parchment guarantee. And the fourth option is what I call the coward's way out, SCOTUS. Could remand the case and simply clarify the doctrine. This means the court would refuse to make a decision on the merits. Instead, they would kick the can back down the road, sending the case back to the lower courts with new guidance on how to apply Bruen and Rahimi. This would be infuriating. We've already seen what happens when they do this. After Bruen, the court granted, vacated, and remanded several cases, and what did the anti-gun circuits do? They didn't change a thing. The anti-gun states are still anti-gunning. They're just doing it harder. We need the Supreme Court to do its job, to grab these rogue courts by the collar and enforce the Constitution. But understand this. The final ruling is about more than just this one law. The decision will send shockwaves through our entire legal landscape. It will signal exactly how flexible or how rigid the historical analog doctrine is supposed to be. That single variable will dictate the outcome of every gun rights case moving forward, whether it's about open carry, magazine capacity, or the very firearms you're allowed to own. As we wait for the oral arguments to be scheduled, there are critical signals we need to watch for. I'll be covering it live, right here on this channel, the moment it happens, so make sure you're subscribed. The final verdict, a republic on the brink. When the justices finally take the bench for oral arguments, every word will be a potential signal. Will the court accept the Ninth's twisted reading of Rahimi, this idea that you can uphold modern laws without a true historical match? Or will SCOTUS pull back hard and demand a much closer kinship to our founding traditions? How will they define sensitive places? Will they finally draw a bright, clear line to stop states from declaring entire cities off limits, or will they give them more leeway to continue their assault? Look for the dissents and concurrences. Sometimes the narrow points made there shape the legal battles for the next decade. And most importantly, who authors the majority opinion? The person writing the decision matters. If Justice Clarence Thomas, the architect of Bruen, pens this one, you can bet it will be a thunderous defense of our rights. My take? I lean strongly towards the Supreme Court rejecting this vampire rule outright. the Ninth Circuit is a radical outlier, and its reasoning is a flagrant abuse of the court's precedent. However, I am deeply concerned they may try to finesse some kind of weak middle ground holding instead of delivering the clean, broad ruling we need to end this once and for all. Now, for that one thing I promised to tell you, the dirty trick you might not hear about elsewhere. Could Hawaii simply do what New York did years ago and vacate its own law before the Supreme Court gets to rule on it? Absolutely. They could repeal the law tomorrow. That would moot the case, meaning it would go away and the Supreme Court wouldn't hear it. But pulling a stunt like that is a high-risk gamble. It could infuriate the justices to the point where they immediately take up other Second Amendment cases like a magazine ban or an AWB case just to drive the point home and punish that kind of gamesmanship. We will see. In the end, this case will tell us exactly what the Supreme Court believes about the Bill of Rights. Do our rights still matter? Or do we need a hard reset in this country? If the Supreme Court does not destroy this law, then the Second Amendment will be hollowed out, rendered a useless ink stain on parchment. They would empower states to create a system where we have to opt in to our own constitutional rights. Name one single right other than the Second Amendment where that is allowed. You can't. A Second Amendment that can only be exercised in the middle of an empty street, far from any sidewalk, parking lot, or business, is not a right to keep and bear arms. It is not your right to self-defense. It is a worthless joke, deserving of a reset. So, what should you do right now? Stay informed. Pay attention to your own state. If they propose an opt-in vampire rule, you know it's time to go to war. Support good litigation groups and your state-level organizations. They are the tip of the spear in this fight. If you found this breakdown useful, like the video, hit subscribe, and ring that bell so you don't miss my live coverage and future updates. Drop your thoughts in the comments, but answer me this. What do you think the Supreme Court will do here? Will they uphold this nightmare, or will they strike it down? Thank you for watching. Until next time, stay safe, stay informed, and stay armed. But most importantly, stay free, America. Take care.